the distinguished chairman of the SLP, members of his ESCO and council, distinguished Leonard Silk and senior colleagues here present, permit me to stand on the established protocol. Good afternoon all. We want to place on record our appreciation to the LSP for affording the tribunal to participate in this wonderful annual general meeting. We recall we were also invited last year at Asaba, and here we are again. We are most grateful. We are most grateful. You know, when you are to do a session after lunch, it's always a problem. Two, particularly after the scintillating session we had about the technology thing. So I don't know whether really we can say anything that will be as interesting as what has been said. But however, we will take a bite and see what we can do. The topic of the conference, the theme is legal practice beyond borders. Now, what is the relevance of the IST and how is IST's practice, or how can it be beyond borders? Beyond borders has a definition from my understanding to say beyond the confines of the courtroom, beyond the confines of also our immediate jurisdiction. And the IST is called Investment and Securities Tribunal. It was established in 2003 after a yearning from the Capital Market Committee that the capital market being a commercial transaction, time is of essence in determining its issues. Why? Because in every business transaction, you look at time value of money. Now, prior to the establishment of the tribunal, all disagreements and interpretation of the laws and regulations regarding the capital market transactions are domiciled with the Federal High Court. Given the fact that the workload and other things that the Federal High Court has to take along, so the Capital Market Committee yearned and agitated that, look, the capital market is the second most important segment of the economy of every nation. Indeed, it provides an avenue for sovereign and corporate bodies to raise capital for infrastructural development and other things. And thus, who are those people that provide that facility? They are called investors. If an investor puts in his money in a capital market transaction, upon maturity, he is unable to redeem it. He approaches the court. It takes 17 years for the matter to be decided. Certainly, the investors will not be encouraged to put in their monies into such a business transaction. So the Capital Market Committee came together and said, look, they had a peculiar case where a matter lasted for about 20 years. As important as that sector of the economy is, so the market yearned for a fast-track dispute resolution organ so that those who will determine disagreements will be people who are not just knowledgeable, they must also be experts with practical cognate experience in law, corporate finance, and so forth. So that by the time they decide on any matter, their practical experience, their expertise is brought to bear in such a conclusion. Therefore, government accepted the Odife panel recommendation to establish this fast-track court, and government said yes, there is need to have a court that will be taken out from the traditional court processes to determine capital market disputes. Certainly in life, whatever transaction you do, disputes are bound to arise, inadvertently or deliberately. And so, what do? Have a tribunal that will be flexible, time sensitive, and bring their expertise to bear. That way, investors' confidence can now be restored in the market, and then business continues. That is the primary foundation, in summary, why the IST was established. From 2003 to date, the tribunal has been in existence. But how has it fared? The tribunal has had challenges of forum shopping. You know our colleagues. They go to Federal High Court, they say preliminary objection, they don't have jurisdiction, it's the IST. Some will insist it's not the IST, it's the Federal High Court. Even in the judgments of courts, there were conflicting decisions really as to whether a subsidiary legislation can take away the power given to the Federal High Court to determine issues that have to do with companies and such transactions. But however, we're happy in 2023, by January, a matter that has dragged typically for 17 or so years was finally determined by the Supreme Court, where the Supreme Court affirmed that as far as capital market transaction is concerned, it is the Investment and Securities Tribunal that has exclusive jurisdiction to deal with. So that decision has now settled the issue of where do lawyers go to if there is a capital market dispute. We are happy with that decision. Now, what is the take-in? As a way of summary, the tribunal is set up to determine matters on or before 90 days from commencement of hearing. How does the tribunal do that? This is just a teaser to what I expect my colleagues on this side to look at. This panel will look at an overview of the capital market and the IST itself. Then we'll look at the jurisdiction. How do lawyers approach the tribunal? What are the regulators? How has the tribunal shaped their regulatory functions? What roles really can lawyers play in capital market transactions? Do lawyers really have a role apart from just litigating? I think there are more other things that lawyers are required to do in the cycle of capital market transactions. This panel will attempt to look at those things for the benefit of our colleagues. Apart from that, have lawyers been appearing before the tribunal? What is their experience? How have the tribunal fared within its lifespan, among other things? So with this little comment, time is fast spent, and certainly I will invite a learned professor of investment law, a lecturer capital markets, an author, and a distinguished member of the SLP, Professor Agom, to open this discussion with a review of what the IST is and how the capital market is run. Gentlemen, may we welcome Professor Agom to the mass paper. Thank you.
Chairman, I guess I have 30 minutes or 1 hour.
You have 10 minutes maximum.
The chairman of this session, the chairman of the SLP, senior colleagues, permit me to adopt the already set order of proceedings. When I got information that I'll be talking at this conference, and on this subject, very dear to me, I had a 64-page presentation to make. But yesterday, the chairman reached out to me and said, look, you only have 10 minutes, And alongside the presentation yesterday, right from the very first session, the premium session and the other sessions throughout, I quickly had to reconfigure my presentation to just 15 slides only. And I want it to be very, to be participatory. So from this side and you on that other side, together we'll go through the 15 slides that I have to set the tone for the conversation. I'm happy that the chairman talked about an event, something that happened, historic as it is, on the 13th of January, 2023, which is simply the decision of the Supreme Court that the Investments and Securities Tribunal has exclusive jurisdiction as far as securities matters are concerned. Now, with this, it would mean that if any lawyer would go canvass issues relating to securities law or securities matter before the Federal High Court, then you are either not being current, and you should be mindful of the current inclination of our courts, that the judges are no longer in a mood to entertain frivolous matters. Now, if you are following the trend, you've seen instances of, courts awarding 10 million naira damages against lawyers, whether the Court of Appeal or Supreme Court. So if any lawyer would go before our superior courts now, take investment matters before these courts, you are doing that at a risk. Sometime this year, too, in the case of Honorable Telma vs. IST, the National Industrial Court confirmed the IST as a civil court. Now, this has great implication, for us in the capital market. So we have a court created by law, enabled by law with all the resource to deal with issues around this area. Now, yesterday in the very first presentation, Bodrick Bozimo, spoke very well, and he made a recommendation that caught my attention, which is simply that, look, it's important to learn from other jurisdictions. But again, when you learn and you adopt to peculiar local or domestic situations. Now, the IST is a national institution of pride. It's something that we all should be proud about, because you'll come to see shortly that it's one institution that has worked over the years. For about 20 years, that this body has, playing this fundamental role as far as Nigerian economy is concerned. This tribunal has given judgments that have developed a capital market jurisprudence, and also provided learning curves for laws and other institutions. Now, in 2018, we had the Federal Competition and Consumer Protection Act, which set up the Federal Competition and Consumer Protection Tribunal. That body was fashioned after the IST. And if you go through our law reports now, you will see very few cases on securities matters. The reason is not because you don't have cases in this area. The reason is simply the success of the IST in dealing with securities matters. So clearly, we have an institution that we should be proud of in Nigeria, and an institution that other countries are beginning to understudy. Ghana would come all the way here to watch the proceedings of IST. Globally, this body has received international recognition because of what they are doing. So, in this conference that we're talking about, legal practice without borders, my appeal to you, friends, is simply take the limit of your practice, do a bit of study of what the IST does, and see how you can bring the factor IST into meeting your client's need and even your own personal need too. Now, next slide, please. Now, let me situate this discussion. Studies have shown, empirical studies have shown that, look, there's a relationship, there's a correlation between the performance of the economy and investors' confidence. Once investors, have the confidence that, look, if they vote fortunes into your economy, they are sure that rights will be fairly appropriated, disputes fairly determined, there's that likelihood of having investors, come into your economy and vote their fortunes. And all over the world, I tell you, global race has moved away so much from arms race to finance. countries all over the world now, either through laws or policies, seek international capital to complement what they have locally. In Nigeria, we also have that kind of situation. Empirically, studies conducted between 2015, we have the Denis Odifer's Committee, we have the Revised Capital Market Master Plan 2015 to 2025, we have the Revised Capital Market Master Plan 2022 to 2025. Now, these reports all insist that for you to have an economy that will perform, you must have a robust dispute resolution mechanism, to assure investors that if there are grievances, these grievances will be fairly resolved. And I tell you that one robust dispute resolution mechanism we have in Nigeria currently is the IST. And I join, our colleagues to just take a look there, ask questions about the IST and see what value you can add to your practice. Move to the next slide. Now, when you talk about the capital market and the kind of disputes you can find, you'll find in the capital market, the disputes are there with you. All over the place now, not just a Nigerian thing, it's a global thing. There's this resurgence of Ponzi schemes, resurgence of unregistered investments all over the place. You hear clients walk to your office and say, look, I put so much money into this company and I can't get this money back. I have received promises and undertaking that, look, if I vote 2 million naira into this enterprise, I'll get paid 15 million naira at the end of the month. So you have these, instances all over you have these cases scattered all over. Now, if you receive this kind of complaint, from your client, you need to sit down and locate where that dispute is. Because when you talk about investments can, in the main, be into two categories. You have investment in tangible assets, and you have investments in intangible assets. Now, when you talk about tangible assets, you are talking about real estate, for instance, land, properties that you can feel. You have investments in intangible assets that you do not see, but they exist, i.e., choices in action. Now, once you plow your funds into schemes in the financial sector, maybe money market like the banks, insurance scheme, pension, essentially you may be talking about securities. And when you are engaged in that kind of investment, you need to be careful. When it relates to securities, because very often your monies will not be taken in Ghana must go and taken somewhere else. No, you have a scheme in which you put these funds. Now, once that scheme is a financial scheme in the nature of securities, it comes under the regulation of the Securities and Exchange Commission, and where there are disputes, the place to go is the IST. So we have the IST, and please move on to the next slide. So common in this area is, what you find is simply that you have voted money into an enterprise, you're not getting your return back, or these monies cannot be paid back to you. Or you have asked your stockbroker or an investment analyst to invest your funds somewhere and you're not getting a return. Or you have share certificates that have been sold without your permission. Or your stockbroker is screaming you off. Now, these are the kind of complaints, friends, you would hear, from, our clients. Now, when it relates to securities, readily the Dispute Resolution Forum is the IST, no longer the Federal High Court, no longer the State High Court. The forum, the proper forum is the Investment and Securities Tribunal. Now, when you talk about investment generally, there are frontiers for resolving disputes as far as Nigeria is concerned. If you go to our Section 6 of the Constitution, you'll find, courts listed there that can handle disputes. So, as Section 6 of our Nigerian Constitution prescribes straight away the hierarchy of courts that would handle disputes as far as Nigeria is concerned. Complementing that is also the various laws that you find. In our banking industry, you have the CBN Act of 2007, and you have the Banks and Other Financial Institutions Act of 2020. Now, these laws also set out institutions that can resolve disputes as far as the money market is concerned. Here, under the CBN Act and BOFIA, you find mention of the Federal High Court, State High Court. Okay? So, you have that for the money market. Now, for insurance, the insurance market, you also have the Insurance Act of 2003. And that law would tell you clearly that, look, offenses under that act, can be taken care of at the Federal High Court, or if it relates to contract of insurance, you go to the State High Court. You have the Pension Reform Act of 2014. That law also talks about, jurisdiction in matters relating to pension, first the Federal High Court, and also that you can resort to arbitration and conciliation. And where you're not satisfied, you can go to the National Industrial Court. The ISA talks about the IST for securities matters. Now, these are the frontiers, these are the courts, these are the dispute resolution systems you find under these laws as far as investment business is concerned. Move to the next slide. Now, this is the setting as far as dispute resolution is concerned. But what is our experience? Go to the next slide, please. Our next slide talks about, go to the next one, talks about the kind of experience you find with our regular court system, And I'll particularly like to mention the case of, is it there? The case of associated discount houses, okay, versus, versus amalgamated security. Now, what happened in that case? A discount house gave out a loan of 120 million, to a customer for 90 days. After the expiration of 90 days, the customer could not pay, and the investment house now proceeded to the Federal High Court. At the Federal High Court, the lawyer raised a preliminary objection that the Federal High Court had no jurisdiction. Acting under Section 22 of the Federal High Court Act, the matter was transferred to the State High Court. Now, in the State High Court, again, the same lawyer raised a PO that the matter ought to have been tried at the Federal High Court. And, of course, in that case, my Lord Justice Acholonu, piqued by, the behavior of the counsel, lamented, and warned that lawyers should not be engaged in this kind of practice. So, from the other dispute resolution mechanisms that we have, Federal High Court, State High Court, National Industrial Court, conciliation and arbitration, these are the kind of things that you find. But at the IST, you won't find this kind of thing. So it's one area where we should look at. Since IST was established in 2003, I can tell you that confidence in the Nigerian capital market has been something else. We have moved from the threshold of 16 billion in 1990, 178 billion in 1995. In 2005, our market leapt to about 1.4 trillion to 10 trillion. In 2008, our market clocked a 12.8 trillion. As I speak to you today, our market has attained about 34 trillion naira capitalization. Now, from all of this, what you can get is simply that, look, you have more confidence in our economy now. And a bit of that we can see, or we can trace all of that to the confidence of investors, that we can glean from, taking disputes before the IST and getting something out of it. Please move to the next slide. For those, if you are interested in data, you find all of this in the graph, Move to the next slide, please. Now, there are reasons why the IST has attained so much. Two reasons I can give readily. One, the membership. Investments themselves, essentially are the areas where law of contract plays out, property law plays out, trust law, and commercial law generally. So you have hodgepodge of, commercial law playing in that area. Now, in resolving disputes in the area of investment, if you do not have that approach, you can never get anywhere. But with the IST, it will interest you to know that the members are drawn from different backgrounds. Lawyers, accountants, economists, actuarial science. Now, if you witness proceedings before the IST, you cannot help but know that, look, there's something unique about the IST. Sometimes you find investors walking to themselves and holding hands, and some even crying and apologizing and promising to restitute. You don't find that, in the other frontiers of court that we have. Under the ISA, you have the requirement for you to be a member of the IST. For the chairman seated here, he's been into regulation. He worked with SEC for a very long time, so he's experienced in this area. For you to be the chairman of IST, you must have 15-year post-call, not less than 15-year post-call, and have cognate capital market experience. You have 4 other full-time members, 3 of whom must be lawyers, of not less than 10 years post-call, and then 5 part-time members as well. In all of this, you would see clearly that the membership of the ISA is drawn out in a manner that would suit resolving investment dispute. In terms of success as well, I've talked about that a while ago, but I tell you clearly that the Investment and Securities Tribunal is a place to go. Now, one final word. Take me to the last slide quickly. Last slide, please. So, in all of this, there's something about the Nigerian spirit in the IST. There's something that you as colleagues can take away from what we are doing here today, because our concern is legal practice without borders. How do you add value to your practice after this conference? A place to look at is the IST. I thank you very much.
When you have a prof dealing a paper, you have problem managing him. Thank you, Prof. In the line of the discussion, I think, yes, he has introduced what the IST is and how it was established. I think there may be need for us to also know what is the extent of the IST's jurisdiction, what can they do and what can they not do. So from that perspective, I will invite Honorable Nosa Osawenge, who has also a very rich industry experience as a capital market administrator, participant, and now an arbitrator or a judge. Gentlemen, we invite Honorable Nosa Osawenge to, within 10 minutes, tell us what is the extent of the tribunal's do's and don'ts.
Thank you so
10
much.
minutes.
Thank you so much. Chairman of session, ladies and gentlemen, all protocols duly observed. I'm Nosa Osawenge. I will describe myself as an avid follower of the twists and turns in the capital markets. Apart from the fact that I'm a lawyer, I'm also a qualified stock broker. So I'm very delighted to have been nominated to speak on this issue, which is quite interesting to me. I would like to begin by defining some few concepts which I hope will make you better understand, or better still, appreciate what I'm talking about. The financial market is divided into 2, the money market and the capital market. The money market is where you raise short-term funds, and it is regulated by the CBN. The capital market is where you raise medium and long-term funds, and it is regulated by the Securities and Exchange Commission. The IST is the adjudicatory arm of the capital market. So everything in the capital market disputes are settled by the IST. Why the IST? Before the IST was established, cases went to the regular courts, and there were delays. And because of the time-sensitive nature of IST, it was thought that a specialized court to settle dispute in that field should be established. And that is why IST was established. And by the mandate given to the IST is supposed to settle matter within 3 months from the commencement of the substantive hearing. The jurisdiction of the IST is as defined under Section 284 of the Investment and Securities Act 2007, which is the enabling law in the market. By that Section 284, the first part of it, Section 284(1)(a), is about the appellate jurisdiction of the tribunal. It's appellate in the sense that before you can approach the tribunal with any case under that part of the session, you must first approach the Security and Exchange Commission, and there must be a determination or a decision of SEC before you can come. If you come directly under that session without going to SEC, the tribunal will say it doesn't have jurisdiction to do it. And this has been given legal backing in UBA, the case of UBA versus Okorocha, where the Court of Appeal held that before you can approach the IST under that first part of the session, you must first go to SEC, and SEC must first decide on your matter. But the second part of Section 284, which is Section 284(1)(b) to F, most of those matters listed there are against SEC. So under those areas, you can come to IST directly. That is very obvious because nemo judes in causa suas, lawyers will say. The SEC should not be allowed to be a judge in its own court. So you don't have to go to them directly. So you can come to the tribunal directly with those matters. Exclusive jurisdiction of the IST. The IST has exclusive jurisdiction over capital market issues. And by Section 284(1) provides that the IST has exclusive jurisdiction to hear capital market disputes as outlined in the session. Also, Section 294 provides that the tribunal shall have exclusive jurisdiction in matters specified in the ISA. That is very clear. But some pundits have argued that the Federal High Court has concurrent jurisdiction with IST in capital market matters. And they cite the case of Professor Kasumu and SEC in support of their argument. But I disagree. I beg to disagree with that point. And that point of argument is not right. Because if you look at Section 251 of the Constitution, 1999 Constitution as amended, which deals with the jurisdiction of the Federal High Court. If you read it from A to S, nowhere is it stated that the Federal High Court will have jurisdiction over capital market issues. And as it is said, what is not expressly stated is deemed to be excluded. Expresso unius exclusio ulterius. In any case, the controversies surrounding the issue of jurisdiction of IST has been laid to rest in the recent Supreme Court decision in Muftu Ajayi and SEC. This is a capital market dispute, and that case is very interesting, and I would like to tell you about it. Sometime 2000, the federal government came out with IPO on AP, and in the prospectus for that offer, the debt portfolio of AP was grossly understated. So one of the core investors raised alarm that there was fraud in what they were coming out with. And upon such investigation, the finance manager who gave approval for that prospectus was sanctioned. So he went to the Federal High Court, and SEC raised objection to it, and the case was dismissed. On appeal to the Court of Appeal, the appeal was dismissed. And on appeal to the Supreme Court, this is what the Supreme Court said. Let me read it out. Based on the foregoing, it implies that any grievance whether on denial of fair hearing by the APC, as it is in this present case, rule of law, equity, farce, or law, should be instituted in the Investment and Securities Tribunal. It is unequivocal that the proper forum with jurisdiction to hear and determine the case of the appellant is the tribunal and not the Federal High Court, unquote. So it is now very clear that IST has jurisdiction, exclusive jurisdiction over capital market issues. Does IST have jurisdiction over pension matters? IST used to have jurisdiction over pension matters under the Pension Reforms Act of 2004. But with the repeal of the Pension Reform Act of 2004 and the Pension Reform Act of 2014, has given the jurisdiction that IST used to exercise in that area has now been given to the National Industrial Court. But you are aware that under the Pension Reform Act of 2014, PFAs, Pension Funds Administrators, are required to invest a certain percentage of their fund in capital markets. It is my humble view that any dispute arising from the investment in capital markets under that area is what IST can settle. Yes. Is IST an inferior court? Some people have said the IST is an inferior court. As a matter of fact, a lawyer went to court. When he came to the tribunal and he did not win his case, he went to the court, and part of the appeal was that IST is an inferior court and should not be allowed to deal on capital markets. The IST is not an inferior court. And those who canvass this point of view, they refer to the Constitution, where the costs, the superior costs are clearly stated. And they say that the IST is not part of it. That is section 6(5) of the Constitution. But if you look at section 6(5)(j), section 6(5)(j) says any other court that may be established by the Act of the National Assembly comes under that. So if you look at that section very well, the IST, you will agree with me, is not an inferior court, it's a superior court of record. And moreover, appeals from decisions of the IST go to the Court of Appeal, just like the Federal High Court. And under section 280 of the ISA, it says salaries, allowances of the chairman, members, and chief registrar of the tribunal shall be equivalent as that of the chief judge, judges, and chief registrar of the Federal High Court. So the IST is on equivalent note as the Federal High Court. It's not an inferior court. Before I round up, I want to pose this question, and that is the opinion held by certain quarters, that if we say the Federal High Court does not have jurisdiction over capital market issues, can we now go and enforce our judgment through the Federal High Court as we do? We enforce our judgment through the Federal High Court. Opinions are divided. Some people say we cannot. But the recent Supreme Court decision in Fongtai Engineering Nigeria Limited, has settled that issue, that the Federal High Court can enforce judgment of IST or any other court where the Federal High Court does not have jurisdiction in that matter. I've summarized some cases that the IST has done here, and I'm sure when they give you the papers, you'll see that. Thank you so much.
Thank you, Honorable Osonwenge. Like I told you, he's a guru in this area. And really, when the law says appeal lies to the Court of Appeal, can you call that an ordinary tribunal? I don't think the law is very clear about that. And I've always been tempted to say this. For those of us who may be who have ambitions of picking up their silk, maybe if you get matters at the IST, within 3 months, you get your judgment. We have a transcription machine. Within a jiffy, you also get your record of appeal settled. So probably it's an easier route for you to approach the Court of Appeal and may also meet certain number of cases that you may be required to be considered for that exalted senior rank. I hope I'm not talking too much. Yes, we will find about the jurisdiction of the IC. It has exclusive matters, but limited to capital market. It does not do anything other than that. It's a civil court. It means it does not hear or take criminal matters. Then how can a person approach the tribunal? On that, I think we need to know about it. I will invite Honorable Jude Oduni to take us through that aspect. Oduni is a retired director from the Federal Ministry of Justice, so he is not used to sitting down and presenting papers. You can see why he has decided to do what he's doing. So, Honorable Oduni, thank you. You have 10 minutes, maybe 8 minutes because you are standing.
Thank you, Honorable Chairman and Session Chairman. May I also stand on existing protocol? A lot of the things that I am supposed to say here have already been said by the previous speakers. My call is to talk on the practice and procedure before the IST. I want to start by saying that apart from the jurisdiction vested in the IST and the powers given to it to do so many of the things we are doing, there is also the power to make rules to regulate our proceedings. And this power has been exercised at least 3 times now. In 2003, the IST rolled out its first rules. The 2003 rules were reviewed and updated in 2014. And just yesterday, that is last year, in 2022, we had a further update of the rules. Some of the powers given to the IST to exercise include some of the powers given to the IST include the power to summon and enforce the attendance of any person and examine persons on oath, require the discovery and production of documents, call for the examination of witnesses or documents, review its decisions, we will get back to that, dismiss an application for default or deciding matters ex parte, set aside any order or dismissal of any application for default or any order passed by it ex parte, and the power to do anything which, in the opinion of the tribunal, is incidental or ancillary to its functions and under the Act. The 2022 rules by Section 291 of the ISA 2007, the tribunal, as I previously said, is empowered to make rules. These rules have been made over the years, and in 2022, because of the effects of COVID and contemporary developments in technology, we had to update these rules further to input and capture the use of technology in our proceedings. But before I go further, this morning, the Milord from the NIC said that they are trailblazers and that their rule is visionary, being that they set the pace on the use of technology. Well, I don't blame most practitioners because I've come to understand that most of us don't even know about the existence of the IST. The 2004 rules of IST captured the use of technology. Since 2014, the IST has employed transcription in all its proceedings. All the proceedings of the IST is reported verbatim. You can get a verbatim report of our proceedings. So we did not wait till 2017 or 2022 to capture technology. And the 2022 rules have gone further to make further inroads into the use of technology. But let me also, we have heard about the jurisdiction. I am sure that we are interested in knowing how we can approach the IST. How do you commence proceedings in the IST? From what my learned brother Nosa said, it is pretty obvious that you can appeal cases from SEC to the IST, and you can also commence a proceeding before the IST by way of originating application. Some people may ask, what are we appealing? What will they appeal from SEC? Is SEC a court of law? Yes, the decisions of SEC have been captured. There is an APC, Administrative Proceedings Committee of SEC, which is a quasi-judicial body that listens and handles and decides on capital market disputes. Decisions from that APC is subject to appeal to the IST. But where you are not appealing cases from SEC, you can come by way of originating application. You will find that under Order 4 of the IST rule. The IST rules also copiously dealt with alternative dispute resolution. This comes under Order 3. I will deal with that later if I have time, but we encourage in a very big way alternative dispute resolution in the IST, and we have alternative dispute resolution centers in all our liaison offices. We have provisions for, okay, of course, when you come to the IST, be ready to pay the filing fees, but the filing fees are nothing compared to what you pay elsewhere, despite the fact that we deal with commercial disputes. Service of processes. The new rules have made it mandatory that the notice of appeal and the originating applications must be served by officers of the tribunal. Before now, parties can elect to serve, but presently, the service of originating application and notice of appeal must be done, carried out by officers from the tribunal. Other processes may be served by the parties who are bringing the application. Reference by the commission. the Securities and Exchange Commission can make a reference to the IST. Again, you may wonder what type of reference. The Securities and Exchange Commission is empowered when there is a market infraction to prohibit trading in the security of market, stock companies, participants in the market. And therefore, some of the time, when the operators are not satisfied that they have been dealt fairly by SEC, they can make a request that SEC should make a reference to the tribunal for their matter to be heard and properly adjudicated. This is provided for under Order 10 of the new rules. Extension of time, of course, it is taken that this will form part of the rules because sometimes, for one reason or the other, not necessarily for tardiness, parties may fail to come before the tribunal within time. Other parties. There's a provision under Order 12 for other parties, not necessarily the claimant and the defendant, the appellant and the respondent, but for other necessary and interested parties to be joined in proceedings before the tribunal.
Prepare to write more.
Motions and affidavits. Provisions are made copiously for applications to be made via motions, accompanied by affidavits and other documentations. Under Order 16, the defendant's defense and final written address is to be incorporated with a preliminary objection. I think this is important because we have had the situation where most of the time practitioners come before the tribunal and the first thing you see them do is to bring a PO. We do not most of the time entertain POs. POs are to be incorporated with a substantive suit. And this saves us time. This is the reason why we have been able to do our work, carry out our mandate within the 3 months. We don't allow cases to come before us and last beyond 1 year. We try to deal with all preliminaries and go into hearing and do our judgment within 3 months. So POs, we don't entertain, we don't go. That is why Professor Agom said that the case he referred to would not have seen the light of day before the IST. Evidence.
Generally, thank you.
Generally,
as a judge, you will need to be. Thank you. You received the loudest applause. Thank you. Yeah, thank you very much. Yes, it's important to note that, like you said, the tribunal can review its decision, but we hardly do that. The tribunal can, on its own, at its own prompting, join a party or parties if that will help in determining the matter. And we have done that a couple of times because we found out, without being arrogant, we found out that most of our colleagues, when they approach the tribunal, they just bring, they bring incomplete parties that will, at the end of the day, make the execution or enforcement of the decision a bit difficult. So we look at it and we normally invite necessary parties, we join them, and they are served the process so that all issues will be presented, will be placed before the tribunal for its decisions, among others. Yes, like I said earlier on, the tribunal has been around from 2003 to date. Like he has said, we've gone through rounds of updating our rules of procedure in order to make it in line with global best practices. I think what he has not said, maybe because of time, is we also do virtual hearing. We have taken evidence from people in US, UK, so that we can give everybody an opportunity to express himself. And I hope we also know that capital market actually is a universal market, because investors across the world can invest. With the new initiatives that have come in, with e-subscription, e-dividend, e-allotment, so wherever you are, you can subscribe. And because of that, the tribunal really had to be in line so that when issues come, we don't have to wait for you to spend your money to fly from Jamaica to come for proceedings. Once your counsel identifies and the issues are joined, we also do that. So we want to hear what has been the experience of our colleagues who have appeared for the tribunal. And somebody who has appeared before both sides of the coin, and sometimes even against his client's interest, in the interest of justice, he has always stood out. So we said, let's share his experience. Consequently, Honorable Alex Moka, can you please share your experience with this House about the tribunal from your practical relationship with the tribunal?
Thank you, Mr. Chairman. Good afternoon, everybody. Just get a sense, can I have by a show of hands those here who have litigated before the IST? Wow, so that's the essence of this presentation. Very few of us. Now, I've been fortunate. I've done quite a few matters before the IST. Interestingly, I've appeared before the chairman, before Noble Uduni, before Noble Nusa. I've done about 4 matters with Mr. Ede representing SEC. So it's almost like family. Seriously, my mission here is to sell the IST. It's, in my opinion, a fantastic court for for resolution of commercial disputes in the capital market. I've had very, very good experiences before this, and I'll tell you why. Now, but do bear in mind, the IST has exclusive jurisdiction for the resolution of capital market litigation. But dispute resolution in the capital market does not often start there. It often starts before the Administrative Proceedings Committee of the SEC. And the reason for that is that SEC is the market regulator. Before you rush to court as a client, for instance, of a capital market operator, you are required to first approach SEC for a determination. And that's the reason why there's been emphasis on the IST having appellate jurisdiction for most of the matters that go before it from investors and all that. Now, the IST is a fast-track court. It is required to resolve disputes, to determine disputes, within 3 months of commencement of hearing. And while that does not always work, I can assure you that the judges of the IST take pains to have been pushed to the wall when it comes to adjournments before the IST. You don't get it for the fun of asking. You must, they're going to really hold you to that 3-month window. So the beauty of it is that you are able to resolve your disputes there very quickly and move on to other things. Now, the IST has highly specialized, knowledgeable judges sitting on its panel. And I'm sure that as practitioners, you can understand the importance of bringing a matter before a court where the judge knows what he or she is doing, where the judge understands the intricacies of complex capital market transactions and disputes. And that is brilliant. Now, how that has helped in practice for me, speaking from my perspective, for instance, is you have a matter before the IST, because of the nature of the court, you can, independently of the applications and the process you have filed, you're able to engage with the panel and reason out issues with them, and they will listen. The IST, in my opinion, is litigant-friendly. Now, on the minor side, one of the issues I have had with the IST is that invariably, when it comes to venue for dispute resolution, the IST is claimant friendly. And how that works out is if you have, for instance, a capital market client who is resident in, the IST has 5 locations, headquartered in Abuja, Lagos, Enugu, Port Harcourt, and Kano. Now, if a claimant has approached the IST by filing in Port Harcourt or in Enugu, for instance, all the defendants might be companies that are residents in Lagos. They are compelled to all proceed to Enugu or PH to resolve that dispute. And that could sometimes, of course, be quite expensive, particularly in cases where the defendant really is not culpable in terms of the dispute. Now, the IST is a very efficient court. You have heard that they've had automatic transcription for very many years. I have had instances where I have been able to, I will travel for a matter, the trial goes on. At the end of proceedings, I can wait and collect a CTC of the transcript of the proceedings before I leave and go back to my base. And that is simply fantastic. If you conclude a matter before the IST and there's need for an appeal, your record of appeal is ready in no time because the transcript of proceedings are ready at the end of every proceeding. Okay? Of course, it's a business-friendly environment. In terms of the nature of the courtroom, they have, of course, very well-appointed courtrooms, air-conditioned courtrooms, very comfortable courtrooms. You don't have to, you're not robed to appear before the panel. So, of course, it's formal business suits for men and all that. So it's quite a business-friendly environment. Now, in terms of the role of lawyers, I like to see the role of lawyers, and there was an allusion by the chairman to that. Our role should be problem-solving. Now, I want to give you an example of how that worked out in a case I did. Now, there was a dispute brought before the IST a couple of years ago, John Cod Nigeria, John Cod Agro versus CSCS and others. Now, an investor had made an investment with a stockbroking house. The house had sold off his securities. And of course, the standard rule, you petition SEC will ask the house to buy back the securities and ensure that the investor doesn't suffer any loss. Now, that didn't happen. The particular house was actually going under and had a number of complaints against them. So, of course, the claimant rushed to courts, sued the house, sued the CSCS, joined SEC in the matter, joined the Nigerian Stock Exchange, which, as you know, is a self-regulating organization, and of course, then joined the registrar that had issued the securities. And the reason for that was the claimant understood that if he got a judgment against the house, there were no assets to recover. So he was interested in attaching the shares that house had been issued following the demutualization of the stock exchange by way of recovering his money. Now, upon reflection, it was clear to defense counsel and even to the judge of the IST that he might get a judgment in terms of a pronouncement that is entitled to a recovery, but he would not have been able to attach the shares that the house had in the NGX, because that ordinarily should have been a post-judgment garnishee application. The NGX and the registrars should not have been joined in the matter from the beginning. Now, what the claimant then chose to do, he had a very, effective counsel, was to then approach the respondents and pursue a settlement. So we were able to achieve a settlement in that matter that gave the claimant the relief he sought. But of course, because the house was also exposed to other investors, there was provision there to cater for other investors and all that. So a business result was achieved. The claimant got his money, or some of it, and everybody was happy. Now, I had another interesting experience before the IST that I'd like to commend to people. An action was filed here in Abuja by, it's public knowledge now, the case is concluded, by Honorable Yakubu Dogara against Cashcraft, another house. He had made some investments on behalf of 2 of his children and his wife in a product that they were selling, and of course his money got stuck. So he approached the tribunal and sued the House. He sued SEC, and he also sued the registrars of NGX, hoping to also get the same thing, shares from the majority exercise. Now, we were representing the registrars, and based in Lagos, we considered the expense of coming to defend an action in Abuja that we really should not have been made a party to, because there was no cause of action disclosed against the registrar in the suit. The registrar should only have been joined properly as a post-judgment application to enforce and recover the sums. So I reviewed the process and I advised my clients, you can save the money. We would watch the proceedings from afar. I had a firm conviction that the panel of the IST would do the right thing. Now, I'm pleased to report that without filing a defense on behalf of that defendant, without making a single appearance in that matter, the IST proceeded to trial, considered all the submissions of the claimant in relation to my client, the third defendant, and gave a judgment exactly aligning with my assessment of the case, at no cost whatsoever to my clients. Now, what is more interesting is that at the end of the day, the judgment was mailed to my clients in Lagos. I don't know which other court you will get that from. So I'm going to commend the IST to everybody in this room. Consider practice before the IST. Thank you.
Well, thank you, Chief Moka. We are happy to hear such positive comments coming from people who have appeared before us. But the issue is justice must be given whoever may be involved. Whether you are there or you are not there, we will look at the matter. We don't do technical justice. We don't do the technical justice in IST. We don't. Now, the IST has served the capital market environment as a whole. Regulators and registrants, capital market operators, and the likes. Now, I want to invite Mr. Ede to give us an idea, really, what roles do lawyers actually play within the gamut of the capital market, apart from litigation? Are there such things? And has the IS really impacted on the regulations of the market by the regulators? Mr. Ede is a legal manager with the SEC, and can we have your view, please, for the benefit of our colleagues? You also have 10 minutes.
Okay, thank you, Mr. Chairman. Good afternoon. I'm really honored to sit in this panel because I'm actually sitting with the Honorable Chairman and other members of the tribunal who I regularly appear before. And then my brother and friend there, Mr. Alex, I also discovered him at the tribunal. So it's really a pleasure to be in this panel. Now, I'm wearing two caps sitting here. One, as a lawyer that has consistently appeared before the tribunal, and secondly, as a lawyer representing the Securities and Exchange Commission. I will start by sharing my experience in the course of practicing before the Investment and Securities Tribunal. And I will say that I've done that for more than 10 years. Okay, so in the tribunal, cases are not mentioned. You don't come thinking that today is for mention. There's no such date as mention. So we just go straight to hearing. Of course, we deal with applications first, and then we proceed to hearing the substantive cases. One one of the honorable members have also mentioned that when you come with a PO, the tribunal will tell you to hold on, incorporate it in your final written address. Next is my experience with tendering of documents. You see, in the course of evidence, when it is time to tender documents, we tender documents as a bundle. And you can imagine how much time that saves. And then lastly, I will mention the way cases are handled. Now, we have held a proceedings up to 1 a.m. at the tribunal. You heard me right, it wasn't a mistake. We've held proceedings up to 1 a.m. Now, and all these are to attest to the fact that the tribunal has a lot of expertise in case management, in time management, and in doing a quality job in terms of the quality of the judgments and the rulings that you get from the tribunal. So that is my experience practicing at the tribunal. Now, representing the SEC before the tribunal, how far have the tribunal helped the SEC in performing its work? On this part, I will speak as an insider. I will tell you that sometimes, in fact, most cases, whenever we are faced with, of course, maybe a complaint or whatever it is that has the potential of being a litigation, we make an assessment. And one of the questions that always come up is, what would the tribunal say in this case? In other words, we try to anticipate the direction the tribunal will go if this matter is presented before the tribunal. And you can really imagine how much that does to our internal processes by making sure that we try to put a lot of things together. I have had instances where in the course of doing a matter, the tribunal will tell me, Mr. Ede, you need to do better. You know, you need to do better. And that simply says that we need to review some of our processes internally. So, bottom line is that the tribunal has consistently served as a check, you know, on the way we do things within the SEC. Now, secondly, there are times that we need very quick orders to be able to preserve certain assets or that may be dissipated if there is a delay. I have a colleague in the office. Whenever we receive a process from the Federal High Court, he tells me, Kachi, you go there. I don't like going to Federal High Court. But once it is IST, he is always very eager to go to the IST. And his reason is simple, that cases are decided very expeditiously at the tribunal. So if I need an order to preserve a res, I prefer to go to the IST to get my orders. The reason is that if I go to Federal High Court, I will find my case. In fact, I filed an application at the Federal High Court like 2 weeks back. It has not been assigned to a judge. Now, that doesn't happen at the tribunal. I could file a matter today. The very next day, I get a call from the registry saying, come for your matter in 2 days' time. And within a space of 3 to 4 or maximum 5 days, I already have my order preserving the rest. Now, the decisions of the tribunal have also encouraged investment inflows into Nigerian capital market. And somebody has really dealt with that, so I won't be going into that. Now, the expertise at the tribunal is brought to bear on the kind of decisions they give, you know, in cases. So you will really, when you read a judgment of the tribunal, you will see expertise in display in that judgment. Then lastly, the tribunal has helped to enrich the capital market jurisprudence. Today you can find a lot of cases. Some of them has been mentioned. There are quite a number of them that have not been mentioned. Some are still pending at the Supreme Court. Some were concluded at the Court of Appeal and the rest of them. And when you read all these cases, last year there was a decision on Nospecto. This year there was a decision on Muftau Ajayi. There are a lot of other cases, Wealth Zone and the rest of them, that are up there. And these cases have helped to enrich the jurisprudence on capital market. Now, in the next 2 minutes, as a lawyer, what opportunity do you have coming into the market, into the capital market? First of all, you can participate in primary offer segment of the market. What do we mean by that? There are some companies at some point decide to go into some form of business combination, be it mergers, acquisition, be it takeover, whatever, and then they need lawyers, to participate in these processes. Then it could also be an initial offering, of securities, the IPO, that company, maybe a private company decide to go public, and it will do its first, public offering of securities. Lawyers are usually involved in that. As a transaction lawyer, you could also be called upon to review offer documents, prospectus, and the rest of them, and those are areas the lawyers can come in. Now, there are, in the collective investment scheme, we have what we call trust deed, and we know what a deed is. So, and these are legal documents that lawyers, are meant to prepare in support of capital market transactions. Now, lastly, there are other areas, other forms of agreements that lawyers can also, prepare. Then, before we also get into the area of handling capital market dispute, which is almost exclusive to lawyers. I think one of the things I have observed is that there is shortage of knowledge, among lawyers in this area of capital market practice. For instance, I review processes from lawyers, and I see things like Security and Exchange Commission. Sorry, that's not correct. I see things like Investment and Security Commission. That's not correct. Once I see that, it just tells me that this person is not familiar with the market. So please, let us step up our game. There's a lot to know, there's a lot to learn, and there's a lot of money to make from practicing in capital market. Thank you.
Thank you so much, Mr. Ede. My learned friends, I think the day is fast spent, and I think we should not belabor the issue. A summary of what has been said, everybody has taken note. Why was there a need for a special court? Because you need expertise. Business transactions are time sensitive. And then there's what we call special knowledge to deal with matters. And then how to approach the tribunal is either by way of appeal or by way of urgent applications. Now, SEC registers all capital market participants. So the law says if there's a dispute between them, they approach SEC first for a decision. If you're not satisfied, you then approach the tribunal. And before you do that, you also need to give SEC notice. But however, there are matters that you can approach the tribunal directly by urgent applications. If the complaint is about inside dealing, accounting misstatements, and things like that. If there is a dispute between an SRO and SEC, you can approach the tribunal directly. And then we are happy, like I said, let me repeat it, that the issue of foreign shopping has ended. So why do you waste your time and your client's money going to Federal High Court when the Supreme Court has made it very clear? Before this pronouncement, there had been two conflicting decisions of the Court of Appeal. Professor Kasimo said he needed not to be registered to participate in an offer. And then he said that as a legal practitioner, he has a right to do whatever a lawyer needs to do. But the SEC said no, before you participate in an issue that was require sex approval, you need to register as a capital market operator with the function of a legal practitioner. I think that is an area that lawyers need to know. So there's big money in it, but you need to register for you to sign up a document, either as solicitor to the issue or solicitor to the offer, or a solicitor in any transaction. Otherwise, SEC will not approve that thing. And I want to assure you, no investor, no party will wait for you to go and get registration before he processes the document. You just drop your name and get another one. That was what happened to Professor Kasuma. Of course, Ajayi, SEC said, we have jurisdiction. They said no. We are happy that has been resolved. So these are the few things that I think I needed to just mention. We want to once again thank the SLP for this opportunity to discuss. And because of time, we will not be able to take questions from our colleagues. So what we do, just like what happened in the last session, if you have issues that you need clarification or a question that you want an answer, just write it and send it through the coordinators of this session. We assure you we will respond to you timeously as is our practice. We want to thank you very much, and for the panelists, particularly to bring Professor Moka and Professor Agom all the way from Lagos is not easy, but we want to thank you. Yes, Moka, you are more than a professor of the capital market. So you are professor. Okay, let me drop that. Thank you very much. Sorry. We also have published decisions of the tribunal. We have a law report called Nigeria Investment and Security Law Report. We have 10 volumes where we published selected decisions of the tribunal. Not all, selected decisions of the tribunal. They are available outside at our pavilion for those who want to buy. For the purpose of conference, now we are giving a discount. I'm using my discretion. We are giving a discount at 1,000 per copy instead of 2,500. For those who want that, they can take advantage of that. And we also have the current rule, the Rules of Procedure 2022 is also available at the Sex Pavilion by the gate. As you go out by you know I'm a lefty, so I have problem with direction. By right, you see them there. Thank you so much.